Why doesn't El Salvador give him due process? He's an El Salvadorian citizen. They can give them all the due process in the world. They're not lawfully here.
The emergency judges 100% of the time get those cases. So he could have been tipped off that this was going to be filed, and while on vacation, he took the case.
A total embarrassment for crazy Judge Boasberg, who's been trying to force this president to bring foreign alien terrorists back onto American soil.
The Supreme Court has spoken. Judge Boasberg blown out. He said, I have authority and jurisdiction to stick my nose over from the judiciary into Trump's executive branch and usurp the will of the American people right out from under us. Now the Supreme Court has said, wrong. That's not how this is happening. And we're excited to see it. Now, we got a 25-pager here, but the real question in response to this is, what is the judge going to do? Because the Supreme Court has spoken, and as we'll see, they say that the judge doesn't have jurisdiction over this case anymore, but for some reason, this judge is still acting. Trump submitted a notice. He says, you really got no choice here to dump this case, so just do it. But here's what SCOTUS said, and the real question, of course, is what happens in this case, but beyond that, does this help to alleviate or curtail or stop any of the floods of similar injunctions or TROs that have been issued in multiple other jurisdictions? We'll see. Per curiam, this is an opinion of the court, came out late last night, says, all right, this matter concerns the detention and the removal of Venezuelan nationals believed to be members of Tren de Aragua that State Department, Rubio, and Trump have designated as a foreign terrorist organization. Now, the president issued a proclamation saying, we're invoking the Alien Enemies Act. We're removing people who are Tren de Aragua. So 5 detainees, which were the people who are the JGG folks, and a putative class, so in this case, it's the class action, right? He certified a whole gangbang group, sought injunctive relief. Now, initially, the court notes from the Supreme Court that they sought relief in habeas, okay? They filed a habeas claim, which is the right claim, but they dismissed that claim when Judge Boasberg was like, hey, if you file habeas, you got to be in Texas. Dummies, they're like, oh yeah, we don't want to be in Texas. We want to be in your court. He's like, well, then get rid of the habeas claim. They did. On March 15th, the district court issued 2 TROs stopping the removal of these people here and a class, which consisted of all non-citizens in custody who were subject to the proclamation, a literal class action of gangbangers in America. Amazing. Judge Boasberg. Now, on March 28th, the district court extended the TROs for up to an additional 14 days. The DC Circuit Court of Appeals denied Trump's motion and an appeal, and the government now is at the Supreme Court. Says, all right, the court, Supreme Court of the United States. Well, all right, Judge Boasberg, we are granting Trump's application and we are vacating your TROs. Bye. Sorry, Judge. The detainees, the people who are subject to being deported, they seek equitable relief against the implementation of the proclamation and their removal under the AEA, right? This is the substance of their claim. What are they asking for? They challenge the government's interpretation of the act, and they assert that they don't fall within the category of removable alien enemies, but we're not even reaching those arguments, okay? So we're not even going to get to the bottom of that. So to be clear, this is not some sort of excuse for Trump that his interpretation of the AEA is vindicated or valid. They're specifically saying that. We're not there yet. But they say challenges to removal under the AEA, the Alien Enemies Act, a statute which largely, quote, precludes judicial review, must be brought in habeas, as we were screaming, I don't know, weeks ago. They cite another case saying holding that habeas was the only case of action, only cause of action available to challenge deportation under immigration statutes, and that it precluded judicial intervention beyond what was necessary to vindicate due process rights, right? And they do have due process rights in their removal proceedings, in their habeas petitions. They're not just rounded up and thrown out of airplanes. They go, they get noticed, you're being deported, okay? Even in this case, they filed a lawsuit before the proclamation was even public. That's how much notice they had. They sued, the judge certified them as a class, so all of the crying about due process, they got plenty of it. So regardless of whether the detainees formally request release, writes the Supreme Court, from confinement, because their claims for release necessarily imply the validity of their confinement, whatever, their claims fall within the core of a writ of habeas corpus, and so therefore it must be brought in habeas. And immediate physical release is not the only remedy under the law. For core habeas petitions, writes the Supreme Court, jurisdiction lies in only one district, the district of confinement. Judge Boasberg knew this. The ACLU gangbang lawyers knew this. The District of Columbia Circuit Court of Appeals, they all knew it. They're all just ignoring this key part of the law to allow the injunction to stand because they're trying to insurrect the presidency via Article 3 courts. Now, the detainees are confined in Texas. So the Supreme Court, even Judge Kagan's like, I have to go with them on this one, says, so venue is proper in the District of Columbia. And so as a result, the government is likely to win. Judge Boasberg, you have no jurisdiction over this case. You never did. You knew you didn't. And then you said that order the planes to turn around. And then you held Trump, or are about to hold Trump, in contempt over that because it's rigged. Now, the detainees also sought equitable relief about summary removal. Now, although judicial review under the AEA is limited, we have held that an individual subject to detention and removal under that statute is entitled to judicial review as to questions of interpretation and constitutionality of the act, as whether he or she is an alien enemy 14 years of age or older. And that was back from the Ludke case, right? And the point has always been there is some due process, but they're not entitled to have, a trial of jury members by their peers or something. They got due process. They got judges. They got appeals. They got a bunch of stuff. Trump gave them due process. What exactly? We don't know the details. Maybe it'd be nice to know. But they're saying we gave him plenty of due process. We're relying on prior orders too, and the status has changed, and they're gone. Under the proclamation, they say the term alien enemy is defined as all Venezuelans 14 years of age or older who are not lawfully here, says the SCOTUS. Now, the detainees' right against summary removal, however, are not in dispute. The government agrees. They do get judicial review. Yeah, in habeas, in Texas, which should be the answer from Pam Bondi, from Tom Homan, from all the people who get asked about this. You're just like throwing them on airplanes and sending them out of the country. No. They get plenty of judicial review. And Papusa Boy saw two judges, lost the first one, appealed it, lost that one, and saw another judge and got some other sweetheart deal because of his pupusas. And he's a citizen of El Salvador. He's not a citizen of the United States. He never had lawful status, and so he's back home in El Salvador. He's a citizen there, so he can figure it. They can do what they want with their own citizens. It's their prerogative. Now, it is well established the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings, and so the detainees are entitled to notice and opportunity to be heard about the appropriate nature of their case. And moreover, in this context, the detainees must receive notice after the date of this order that they are subject to removal under the act, right? And they got notice. Now, we don't know the details of the notice, and this is part of what Trump is doing. He's defending the tools and the tactics of the executive branch. He's saying, this is our prerogative. You don't get to tell us how to run our executive branch. We gave them due process under the law, and they're gone. Like, this is the court giving a little notice to Trump and the Trump administration. Now, that notice must be afforded with a reasonable time and in such a manner as will allow them to actually seek habeas relief in the proper venue before the removal occurs. So they'll probably just set some standard, 14 days. You're going to get removed in 7 days, 14 days, or else. Now, for all the rhetoric, writes the Supreme Court, of the dissents, the whiners, today's order and per curiam opinion confirms that the detainees subject to removal orders under the AEA are entitled to notice and an opportunity to challenge their removal, all of which they've gotten. So for the reasons set forth, we hold that venue lies in the district of confinement, which is Texas. The dissents from the two libs would have the court delay resolving that issue, requiring that, given our decision today, that the process begin anew down the road. Now, we see no benefit in such a wasteful delay, and so the application to vacate the orders of Judge Boasberg that came up through John Roberts and referred to him are granted. The application is granted. So your orders, your TROs, Judge Boasberg just got a fueta'd right out of the courthouse. So the March 15th, 2025 minute orders granting TROs on two dates, the March 15th and March 28th, the extension and the original TRO are hereby vacated. It is so ordered, signed by a per curiam opinion of the Supreme Court, which is an opinion of the court. Now, Judge Kavanaugh, with whom Judge Boasberg went to law school, but Kavanaugh rules against him here, concurring with the per curiam opinion. He says, now I agree with the per curiam opinion here. Importantly, as this court stresses, the court's disagreement with the dissenters is not whether the detainees receive judicial review of their transfers. In fact, all 9 members of the court agree that judicial review is available. Yeah, we've always said that. Hello. The only question is where that judicial review should occur. Now, that question on venue turns on whether these transfer claims belong in habeas proceedings or may be brought under the APA. Now, I agree with the court. Must be habeas. Now, I add only that the use of habeas for transfer claims is not novel. We do this all the time. In extradition, we did it here, Obama cases, Ludke, and more. And so there's a lot of history and precedent of using this, and especially using habeas claims to review transfer claims, right? When somebody's literally being transferred from here to another location. Bunch of other cases did it, so we've done it before. Habeas can handle those. And you can't sue under the APA when there was another adequate remedy in another court, and that's in the habeas courts in Texas. So go over there and get it from Judge Kavanaugh. Now, the dissenters here, and Amy Coney Barrett joins in as to some of these components. So we've got Sotomayor. This is kind of a split decision, right? Because we got Justice Kagan, Jackson join, the three of them, and and Barrett is joining as to 2 of them, but leaving off the other 2. So you can see we've got 3 judges here, and the per curiam is the other component. So this would be a 5-4 decision based on the numbers we see here. Now, 3 weeks ago, the federal government started sending scores, this is the dissent, of Venezuelan immigrants, not nearly enough, detained in the United States to a foreign prison in El Salvador. And here you go. It did so without any due process of law. It's just not true. Under the auspices of so-and-so, right? The majority says there was plenty of due process. And now the district court put a pause on this, but the majority thinks it's fine. But even the majority agrees, and the federal government now admits that they are subject to judicial review, right? Everybody's agreed to that always. So the court's legal conclusion is suspect. They say the court intervenes anyway, and it doesn't even mention the grave harm that the erroneously removed El Salvadorians are going to face. Got it. All right, so Amy Coney Barrett joined in parts 2 and 3B. Let's see what some of these are. They write, this case arises out of the Alien Enemies Act. Trump said it's coming in place, and James Madison said this is a big disgrace and a bunch of stuff. Now, to that end, the act grants the president the power to detain people. It's only been used 3 times, they say. War of 1812, World War I, and World War II. But then that changed. Trump came in, and he invoked it and used it against Tren de Aragua, issued a proclamation and more findings. Now, suspecting that the president had covertly signed a proclamation somehow, I guess they just guessed it, several lawyers anticipated their client's imminent deportation and filed a class action lawsuit. Kind of. I mean, the judge certified them as a class of gangbangers, but it sounds like they got plenty of notice. So it sounds like the judges are admitting there's notice here. Now, they contested that Tren de Aragua had committed a type of invasion and said, we didn't do these things. So then in the early morning, right, the lawyers sue. The district court informed the government of the lawsuit, scheduled a hearing. Judge Boasberg got the case, popped out of nowhere, and issued an TRO. The government, they thought, was to rush this through. They say JGG, for example, had no chance to tell his court that the tattoos causing DHS suspect him as a gang member were unrelated to a gang. He says, no, I'm a tattoo artist who got an eye tattoo because he saw it on Google and thought it looked cool. So that's his excuse, you know. We needed time so he could explain that to a judge. And then some hack judge would say, it is cool. Yeah, it is cool, JGG. You should stay in this country. GFF was also denied the chance to inform a court that the government thought he was Tren de Aragua solely on the presence of strangers because some friend said he was part of them. Now, again, just to be clear, these people are not being charged with crimes, but they are being deported from the country, and they're not lawful residents. They're not lawful aliens. They're not citizens. So they shouldn't be in the country anyways. Now they're just saying, well, they need an opportunity to challenge their designation as a gang member and deport them, out of the country. Now, recognizing the emergency that the government had created by deporting them, then the judge issued a TRO, and ordered the plane to get turned around. The court set an emergency hearing, and despite this, they continued to load up the planes. Now, this is going to come back down. This judge is not letting go of this case, obviously. So he said, guys, come on back and let me know if you can keep this case going, even though the Supreme Court said you have no jurisdiction at all. This is what it's going to come down to. It's the impeachment and contempt trap. Not until an hour before the hearing did the website finally have the proclamation published. So then at 5 p.m., the judge certified the gang members as a class and said, you can't deport any of these people. Concerns about their compliance began to emerge. The district court, for its part, has surmised that the government knew about the order but was evading the judge's order and kept deporting these people out of the country. Now, this prison is going to cause a lot of harm. SCOTUS, the record reflects that inmates are highly likely to face life-threatening harm. The liberal judges and Amy Coney Barrett are freaked about that. It says SCOTUS detainees are frequently denied communication with lawyers, saying they'll never leave. You've seen it. It's a brutal prison, no doubt. What if the government later determines that it sent one of these detainees there in error? Or the court decides the president lacked authority. The government takes the position that even if a mistake is made, they can't get this person back. We saw that with Papusa guy. Now, the implication of the government's position, well, he was an El Salvadorian, so then he can go through El Salvador's government with Nayib and figure it out. But he's not an American, and he's not lawfully in our country. So he's now in El Salvador, back in his homeland, and they can deal with it. The implications of the government's position is not like, why doesn't El Salvador give him due process? He's an El Salvadorian citizen. Why don't the Venezuelans who are upset about going to Venezuela complain to their government? They can give them all the due process in the world. They're not lawfully here. The implication of the government's position is that not only non-citizens, but also U.S. citizens could be taken off the street. And this is a lawless type of regime and more. All right, so to begin with, they say all 9 members agree. The court order dictates today that they're entitled to judicial review, right? And that can come in the form of many different ways. Like you call them administrative law judges, immigration judges, somebody just saying, yeah, no, that was great. We saw that with Papusa boy. Therefore, under today's order, courts below will probe the meaning of invasion or predatory incursion and so on. And so today we agree that the Fifth Amendment requires notice and more, and it sounds like Amy Coney Barrett is agreeing with some of that. Now, against the backdrop, the U.S. government's unprecedented deportation is occurring even though it's without due process. The reason apparently is that the majority thinks Trump's claims should have been styled as habeas actions, right, is what the majority said. But here, all they did was issue a 14-day halt on the deportations. And so by vacating this, you're allowing these deportations to continue, and the dissent continues, saying there is reason to say that this is not a habeas relief and that maybe it is another claim that could survive under the APA. And so they're going to give them another shot. It continues, and we'll see where it wraps up. The government's conduct poses an extraordinary threat to the rule of law. There you go. All right, so what you'd expect. That a majority of this court now rewards the government for its behavior is indefensible. We as a nation in a court of law should be better than this. I respectfully dissent. All right, so Jackson also dissented, and that's fine. So Trump got the actual majority order and sent this back into Judge Boasberg before Boasberg said, well, I'm going to keep this case alive. They sent to the judge, they wrote, all right, Trump respectfully provides notice that the Supreme Court issued a decision today in Trump versus JGG, and it vacated your temporary restraining orders. Now, as the Supreme Court made clear, the ACLU gangbanger lawyer claims must be brought through a petition for a writ of habeas corpus in the respective districts of each individual plaintiff's confinement. So no class action, and they can sue on their own, one at a time. So the detainees are in Texas, so this case should be brought is in Texas. DC is not appropriate. So this court, writes Trump, therefore lacked authority to enter and to extend the temporary restraining orders. And so based on the Supreme Court's decision, the ACLU's motion for a preliminary injunction should be denied. And this case should be dismissed because you don't have jurisdiction. You have no power here. Now, furthermore, says Trump, the Supreme Court decision also eliminates the basis for this court's order to show cause, which should therefore be dissolved as well. As you can see, Mike Johnson, celebrating the SCOTUS verdict, came out and said, we're making America safe again, responding to Pam Bondi, who said, breaking, the Supreme Court sides with the Trump administration on the Alien Enemies Act, saying, tonight's decision is a landmark victory for the rule of law. An activist judge in Washington, D.C. does not have the jurisdiction to seize control of Trump's authority to conduct foreign policy and keep the people of America safe. And so the DOJ will continue fighting in court to make America safe again. So Johnson said, yep, tonight SCOTUS ruled that the Trump administration vacating the stays that prevented deportation is now gone. The decision is a victory for the rule of law and allows Trump to continue to protect Americans. So that's from Johnson. We also had Kristi Noem celebrating this. She posted, saying, President Trump was proven right once again. SCOTUS confirms our commander-in-chief has the power to stop the invasion of our country by terrorists using his wartime powers, saying, leave now or we will arrest you, lock you up, and deport you, and then she's going to come watch you outside your prison cell.
Today is a bad day to be a terrorist in the United States of America. Today, the Supreme Court came out with a decision that reaffirmed President Trump was correct in using his authority, using the Alien Enemies Act to deport terrorists out of this country. Thank you, President Trump, for your leadership in making America safe.
All right, so Kristi Noem explaining what's going on and thanking the president for getting it done. Now, we also saw this. Eric Schmidt, who is now a senator, was on with Fox, and he was responding to this comment about Judge Boasberg getting assigned this case very strangely. And Julie Kelly posted about this over the weekend, got her hands on the transcript, kind of read through it, and it feels very sneaky. The judge was like, oh, no, I just happened to be checking my phone randomly, and I saw the case came in, and I just thought, since no one's available, I guess I can launch on this one. It turned out to be this really important case. Like, okay, judge, no one believes it for a minute. So Eric Schmidt and others are making that comment saying this judge feels like he's trying to talk his way out of it. Here's what the senator said.
Judge Boasberg, over the weekend, it came out, he's not the emergency judge in D.C. He inserted himself in that role. He was on vacation. The case was filed at 2:30 in the morning. Somehow he ended up with that case. He wasn't the emergency judge on duty. So I think this requires further investigation and legislation.
So let me get that straight, because I'll quote you on that, because that is news to me and maybe a lot of other people too. If he wasn't the emergency judge who would naturally matriculate into that position on this, he just gets to pick himself and say, well, I'm the favorite. Let me go do this case against Trump.
He's the chief judge and he inserted himself. That doesn't happen. The emergency judges 100% of the time get those cases. cases. So he could have been tipped off that this was going to be filed, and while on vacation, he took the case. So again, this speaks to, I think, the very aggressive, unusual, and unprecedented measures that these activist judges are taking to insert themselves. Ultimately, they're not going to be right. The Supreme Court's going to slap them down. But the Judicial Conference, Chief Justice Roberts ought to look at this. And we also, the Article 1 branch, I intend to file legislation to make sure this randomness, which is supposed to happen when these cases are assigned, actually happens. We need more transparency because right now, people don't think it's random at all.
So what I think you are getting at is the politics that potentially are being played, where a judge who may feel a certain way politically may step up against Trump at this point. So it fits right in with a brand new opinion piece titled "America Has a Robed Politician Problem," arguing that the left, unable to secure their agenda at the ballot box, has turned to national injunctions as a weapon to engineer outcomes they could not achieve democratically. What's your take on that?
Yeah, I mean, this is really the fundamental difference between a conservative justice and a liberal activist judge. The conservative will view the law as it's written, not how they want it to be. But the liberals, for a very long time in this country, they had control of the Supreme Court. They just made up things. They made up rights that didn't exist to get to a political outcome. Now that you have a more conservative court, they're desperate. They're not in power in Congress anymore. And so I think a lot of these judges are taking it upon themselves to usurp really important power. For example, when President Trump declared a predatory incursion of these criminal violent gangs, he's well within his Article 2 executive power to deport them. He can do that. The judge, by stepping in there, Judge Boasberg, by stepping in the case that we're talking about, he somehow got, said you can't do that. That is like that judge dictating missile strikes or deciding troop movements. Those are national security issues. Those are powers of the commander-in-chief that the judge doesn't get to do. So the separation of powers works both ways. You don't get to kind of jump into the Article 2 branch's authority on commander-in-chief powers. So I think you're about to see all these cases make their way to the Supreme Court, and I think President Trump's on very firm ground. But we should address these abuses that are happening now every day.
We should. Congress should do something about it, even if it is just something symbolic to rub the noses of the bad judges in the history books to say, look, you got hauled in front of Congress for testimony or subpoenaed, or we held impeachment inquiries, or there was a vote even on an impeachment resolution. Like, just get a vote on it. And we'll see if their attitudes start to change a little bit. Now, obviously, a lot of them are purely partisan actors at this point, so they may not care about it. But he's right. The judges are acting as though they are presidents. We also had Stephen Miller was out explaining his take and just how absolutely devastating this was for Judge Boasberg.
This was a huge, a monumental victory for President Trump. The biggest legal win of this administration so far. A total embarrassment for crazy Judge Boasberg, who's been trying to force this president to bring foreign alien terrorists back onto American soil, trying to turn our planes around, trying to empty prisons in foreign countries and bring them back to our soil. This is a monumental, colossal victory for the rule of law, for the Constitution, for our founding generation, John Adams, who signed this law into effect in 1798, and for President Trump in fulfilling his mandate and campaign pledge. What does this mean for you and your family watching at home tonight? It means that the Department of Justice, FBI, DEA, ATF, the U.S. Marshal Service, Customs and Border Protection, Border Patrol, and Immigrations and Customs Enforcement now have maximum authority to find and remove illegal alien gang members from Venezuela that have been responsible for so much misery in this country, for the torture and murder of Jocelyn Ungary, for the brutal slaying of Laken Riley. Those monsters can now be hunted down and expelled from this country with speed, force, and efficiency. This is a great day for America, Sean.
Yes, it is there, Stephen. And thank you for delivering that message with some vigor and some poise. We appreciate that. So it was a big day. Judge Boasberg blown out. And this saga will continue, no doubt about it. So now their complaints will be filed in Texas. There will be more lawsuits coming. I think the ACLU is already typing up one right now as we speak. They're all like, oh, our gang members are under attack. Let's help. So we'll keep our eye on it, my friends. Thank you for subscribing and joining as we do. And we'll see you back here on the next one.